Harley.
Right, so this is, looks like two files, 26-7141 and 26-7146. Looks like I've seen Mr. Harley on one of these files before, but they're both up for arraignment. I think there was a bond issue before, an arraignment and then some show cause issues. So for purposes of arraignment in both files, have you had a chance to review the charging documents with Mr. Harley?
I have, Your Honor. We've waived the reading and same.
Okay, and in both those files, how's he wish to plead?
At this time, not guilty.
All right, we'll enter a plea of not guilty on his behalf in 7141 to the possession of modafinil, habitual third, and a couple misdemeanor traffic. And in 7146, possession methamphetamine, drug double habitual third, and possession buprenorphine, drug double habitual third. We'll enter pleas of not guilty in all of those files. And is a forensic center referral requested?
Not at this time, Your Honor.
Okay, what'd be the estimated length of trial in both of them?
I imagine day to 2 days.
Okay. Would they both be appropriate for a docket call in about a month, June 9th?
I would think so, Your Honor. That sounds good.
Okay, set that for 1:10 in the afternoon. 6. And strikes me that this would be a case that's straightforward enough to be appropriate for a rocket docket, where that first docket call would be the plea and motion cutoff. Would you agree, Mr. Kaminsky?
Right out of the gate, the court is juggling multiple possession charges and habitual offender enhancements and that habitual third label. That's legal shorthand for the stakes just got a whole lot higher. Prosecutors use prior convictions to push for tougher penalties, which means this arraignment isn't just paperwork. It's the opening move in a much bigger chess match.
Yeah, that'd be fine, Your Honor.
Okay. Ms. Goodrich, any reason why that wouldn't be?
I believe we have the lab test.
Oh, okay.
That would be the only delay is if we had to send it.
Okay. All right, so we'll set that, both of those. All right, so now I know in 7141, I amended the bond, right, to, I amended the bond. Oh, but then we still have a pending bond violation hearing on for catching the new case. So for that one, I imagine we should just continue a status conference on that violation till the docket call.
I would ask the court to do that,
An
yes.
objection, Ms. Goodrich?
No objection.
Okay. All right, now and I had amended the bond so there were no special conditions, but then 7146, which was bound over after that, we have a couple. Oh, so here's 714. Well, so in 7146, Mr. Harley, I have 3 separately signed show causes. The first one was signed by me on March 26th. It alleges that you're in contempt of court for violating conditions of your bond in that file by submitting 2 dilute drug screens, one collected on March 23rd and one collected on March 19th. Then I signed another show cause on April 20, alleging that you're in contempt of court for violating the conditions of your bond from a positive drug screen collected on April 2nd for buprenorphine and also for cocaine. And then on May 8th, I signed a show cause that alleges that you're in violation of your bond, contempt of court for violating your bond, or on April 29th, submitting a urine screen that tested positive again for buprenorphine and cocaine. You've got the right to have a hearing on those allegations. I'm sorry.
Did you catch that phrase, rocket docket? That's courtroom language for we are not wasting time here. The judge is basically signaling either this case resolves fast or we're speeding straight toward trial. And honestly, when a judge starts talking efficiency this early, both sides know they'd better come prepared. Intro, intro, intro. Now the tension really spikes. What started as a routine arraignment suddenly turns into a bond violation showdown. Multiple failed drug screens, contempt allegations, possible jail time. This is the moment where the judge stops looking at the original charges and starts evaluating one thing. Can this defendant actually follow court orders? That's a huge deal in bond decisions.
There were two of them. Another one, May 4th, again, buprenorphine and cocaine. Do you have a right to a hearing on those allegations where your contempt would need to be proven beyond a reasonable doubt? You have the right to the assistance of your lawyer at that hearing. If I find you to be in contempt, I could jail you for up to 93 days. I could fine you for up to $7,500 for both. Also, if I believe you're not complying with the conditions of your release, I can revoke your bond. Do you understand the rights that you have and the penalties that you could face? And Mr. Kukeski, do you know how he wishes to proceed on those new show causes?
Well, Your Honor, we'd be asking for a hearing. I did not receive the first violation of the loop test, but we have discussed the positives, and he has some prescriptions that certainly might be the cause of these positive testing. I'm not sure if that came up from district court as well, the prescription that he's on, but certainly he's been treating with his mental health doctor and his current doctor. He's on Suboxone, and I know they test him regularly there too, to make sure he can continue that substance. And so we're a little perplexed by that, and would like a hearing to investigate that a little bit further.
This is where defense strategy gets fascinating. Notice how the attorney immediately points toward prescriptions, treatment programs, and mental health care. That's not random, it's an attempt to shift the narrative from criminal behavior to medical explanation. But then comes the problem no one in that courtroom can ignore: cocaine. Doesn't exactly fit neatly into that defense.
Okay, so we'll enter a plea of not guilty on those show cause contempts. And Ms. Goodrich, do you have any thoughts about that? I know that we've been trying to sort out with the testing agencies the screening issue versus confirmed. And I think we're close to having that solved. If it hasn't been solved moving forward, but these ones came through as screened. So before there's a contested hearing, you'll need to take some effort to sort that out.
Okay.
Do you have any thoughts as to how to go forward from here?
Well, Your Honor, it is concerning, based on it being a possession of methamphetamine case, that he is testing positive for cocaine. The Suboxone prescription, if he's able to produce that, explains the buprenorphine, but it does not explain the cocaine.
Okay. All right, well, I'm going to set this then for a status conference on the pending violations at the same date as the June 9th. And Mr. Kukeski, it sounds like would like to have a contested hearing. I don't know whether you'll have enough proofs to go forward on that date or not. I'll let you two talk about that, get the prescription sorted out, how we're going to get a confirmation of that screening test result.
Very good.
The other thing, is Mr. Harley, you perhaps gathered from a previous hearing, and it would be true that, the little bit that I know about these cases, my mind could certainly be changed by the prosecutor, but the little bit that I know about these cases.
So honestly, this might be the most revealing moment of the hearing. The judge practically says, "I don't want to lock you up, but don't test my patience." That's a rare bit of courtroom candor. You can hear the balanced judges constantly wrestle with accountability versus rehabilitation, and the warning couldn't be clearer. This defendant is running out of second chances.
These are not cases that I would be really excited about locking you up for a long time. And I'm not excited about revoking your bond in these cases. But I don't want you to make the mistake of thinking that then you can just do what you want when you're on bond. All right, so it's possible there's something going on with that test because it is just a presumptive screening. So we wanted to go forward and see if we can get this sorted out here. But you want to be open and honest with Mr. Kukeski about whatever's going on with you. And on June 9th, we'll be back. That'll be a plea and motion cutoff. And hopefully, you and your attorney with the prosecutor can get this case sorted out, or if not, we'll schedule it for trial. This is your right, no problem. And it's, for example, if that if we ask them to confirm those results, that they're gonna find it's cocaine, you best tell Mr. Kukeski about that now, and we can come up with a treatment plan instead of a lock you up plan, okay?
Yes.
All right.
And we did discuss, I asked them if they had the ability to send them for confirmatory testing. I know sometimes the agencies do that, but we have discussed that option going forward.
Yeah, I think they do. It's just a matter of it wasn't done. So I think the conditions of bond would be that your client bears the responsibility of paying for that.
Yes. Yeah.
So let you and Ms. Goodrich kind of talk that through and see logistically how to do that. Going forward, we've been working with the agency to see if that can just be confirmed, when we get those initial results.
Sure.
But that didn't happen here. All right, anything further from the defense today?
No, Your Honor, thank you.
From the people?
No, yeah, thank you.
Okay, I'm going to continue your bond, Mr. Harley, but I'm starting to get nervous about that. So don't make me more nervous about it. All right, we'll see you then.
Thank you.
All right, let's go off the record until our next case will be 2:10 or 2 o'clock. Bringing from the jail, he waived, so we don't need. I have somebody zooming in from Emmett. Who would that be right now? Gillette. Oh, I'll bet you that's Gillette, and he's just a little bit early. Okay. All right, let's go off the record. All right. Excuse me, we're back on the record, and we've got the Emmett jail zooming in. Here, I presume I'm Mr. Gillette. I'll get that situated. All right, Mr. Gillette, can you see and hear me fine?
Yes, can you hear me?
Yep. All right, this is People v. Christopher Gillette. It's 2 probation matters, 22-6490 and 23-6535. Counsel, you want to state your appearances, please?
And good afternoon, Your Honor. James Gilbert here on behalf of Mr. Gillette.
All right, and we're here for probation violation hearing based upon the alleged violation of law in Emmett County. Do you know how Mr. Gillette wishes to proceed?
He is going to admit that he entered a no contest plea in Emmett County.
All right, Mr. Gillette, you want to raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can put your hand down. Mr. Gillette, you understand you have the right to a hearing where the allegations of violating probation would need to be proved by a preponderance of the evidence. You have the right to the assistance of a lawyer and to present evidence in your own defense and question witnesses presented against you. Do you understand those rights?
I do.
You are on probation to me for larceny over 1,000 and for a receiving and concealing stolen property over 1,000. Both of those are 5-year maximum penalties. I think they're concurrent, but I could revoke your probation and sentence you to the maximum in both of those files. Do you understand that?
I do.
Has anybody promised you anything in exchange for your plea to violating probation?
No, sir.
Has anybody threatened you to make you make that admission?
No, sir.
Is doing so your own free choice?
Yes.
And how do you wish to plead to violating your probation? Guilty or not guilty?
Guilty, Your Honor.
So were you on probation to this court for the charges that I outlined?
Yes.
As part of that probation, were you ordered not to engage in any assaultive or threatening or intimidating behavior?
Yes, Your Honor.
And as part of that probation, were you ordered not to break any laws of the state of Michigan?
Yes, Your Honor.
Whoa, the atmosphere changes instantly here. We just went from probation violations to an admitted no contest plea tied to armed robbery, and legally that's devastating for probation. Why? Because probation is built on trust, the court gives someone freedom under conditions. A new felony charge, especially a violent one, tells the judge that trust may have completely collapsed.
Have you now pled no contest to a felony crime of armed robbery in Emmett County with an offense date of January 5th, 2025?
That is correct.
And is that January 5th date, were you on probation to me at that time?
I was.
Okay, and the court would take judicial notice that armed robbery is a violation of state law and it is also threatening or intimidating behavior. Mr. Gilbert, do you think there's a sufficient factual basis?
I believe there is. Thank you.
Mr. Juliet?
Yes, there is.
All right, and are you aware of any promises, threats, or inducements, Mr. Gilbert?
I am not.
Mr. Juliet?
I'm not.
All right, Mr. Jolette, I find your plea to be knowingly, voluntarily, and understandingly made, and that there is a sufficient basis in fact and law to believe that you have violated your probation. So I do accept your plea. Do you know when your sentencing date is in Emmett County?
It's scheduled for June 30th, Your Honor.
June 30th, okay. All right, I think it might make sense for us to do our sentencing before then.
I do also, Your Honor.
Okay, could we add this for the June 9th for your
Sure.
probation violation report? Okay,
And Your Honor, Mr. Juliet does not want to be present. He'd like to attend that by Zoom.
okay, so Mr. Jolette, we can bring you over and do it in person, that's not a problem at all. But if you'd rather just sit tight where you're at, we can do the probation violation sentencing, just as we've done all these other matters and have you zoom in from Emmett. Mr. Gilbert says you want to zoom in from Emmett. Is that your wish?
Yes, sir.
Okay. If you change your mind, you just let him know and we'll get you routed over.
Okay.
All right. So we'll schedule this for a sentencing hearing in both files on June 9th at 2:30 in the afternoon.
And then, almost unbelievably, the courtroom tension breaks with a tiny joke about mixing up the attorneys' names. These little moments happen more than people realize in courtrooms even during serious hearings. It's a reminder that behind all the legal language, deadlines, and life-changing consequences, these are still human beings trying to navigate incredibly stressful situations.
And it'll be a Zoom appearance for defendant. And Ms. Goodrich, you can make those, you can submit that writ. Anything further from the defense?
No, Your Honor. Thank you.
Anything further from the people?
No, thank you.
Okay, I'm sorry, I said Ms. Goodrich, it's Mr. Juliet's case, I'm sorry. At least I didn't call you Mr. Nightingale. All right, Mr. Jolette, we'll see you by video on June 9th at 2:30 and get these probation cases out of the way for you so you can deal with your main case over there, okay? You have a good day, sir.